Good morning, counsel.
Good morning. May it please the court. Jeffrey Baylor for Mr. Cavitt. Here we contend that Mr. Cavitt's motion for new trial should have been allowed where the affidavit in support of the warrant application failed to set out probable cause for the search and the ultimate seizure of red and white sneakers from Mr. Cavitt's residence. Prior to trial, Mr. Cavitt filed a motion to suppress based on this affidavit, contending that probable cause was lacking and that the affidavit was based on an anonymous informant whose reliability wasn't demonstrated.
Wasn't the anonymous informant Miss Lavoie?
During trial, it came out that it was Miss Lavoie.
But, well, you should finish your sentence, because you argue that too. I mean, it's not your first argument, but,
Right.
but you do argue it.
Yes, I'd be happy to discuss it now, though. We contend that even though it came out at trial, it was Miss Lavoie, based on the affidavit, which is all that can be considered in terms of a motion to suppress based on the four corners of the warrant, that her status, her reliability was not demonstrated
Knew
in the
where she
affidavit.
lived. They knew so much about her. The fact that her name isn't used. I mean, if identifying yourself is important because you're subject to sanction or some adverse action if you're lying because the police know how to find you and all those things, that's certainly true of her.
We contend that it's not. I mean, there's information, like she said where she lived, but it was never confirmed by police. There was just a bunch of information given to police that anyone could have said, I live at XYZ Street, but if no one is confirming it, then, I mean, that's where the search took place. So they're using her statement that that's where I live to justify the search, and then checking out, oh yeah, that is where she lives, after the fact. They didn't confirm any of the details of her statement. She just talked generally. I know Mr. Cavitt. She identified clothing that they showed her that was found.
Did she say she was the girlfriend of his brother?
I don't believe so that she said that in the affidavit. Maybe she did, but even if she did, then that, again, that's not something that would go to her reliability. That might go to how she knows this information, but it's not like a detail that is verified.
Well, it's all kind of identifying who she is.
Right,
That's, oh, okay.
but for example, the case is cited by the trial judge saying that this person was readily identifiable. Those cases, the person was readily identifiable. One case dealt with caller ID and the person knowing that police knew who she was. And the other case dealt with police seeing someone leave a motor vehicle and noting the license plate and being able to track down who the person was. Here, there was an anonymous caller. There's
Excuse me, but with respect to those facts, in each case, wasn't just the ability to track down? It wasn't that they, in fact, did check on the number or on the license. It's just that this was information that was in the possession of police so that they could have done these things, as they could have, but didn't need to in this case. It was available to them to verify. I believe that's what those cases
Well, right, and I think it goes to the witness. The witness knew that police could find out who they were. So that would go to her credibility.
It's an inference based on the fact that what was conveyed and provided, as in this case, if you give enough detail about who you are and where you live, it would be a reasonable inference that police could find you.
That's true, but in this case, it's based on what the witness was saying rather than these other, like the license plate or the caller ID, which isn't. Here, she could say anything. And it might work out that it's true, like when they execute the search, but there has to be the basis for the search in the first place. Here, it only indicates that she wanted to remain anonymous. She called. There's no indication that there was caller ID. In fact, one of the documents attached to the Commonwealth's brief says that the police didn't even have caller ID. They didn't pick her up at her house. They picked her up in a parking lot, and then they took her to the police station where she gave her statement. And all it said was she wishes to remain anonymous out of a fear for her safety. In the Rojas case cited in my brief.
Let me ask you this question. Let's say the affidavit had used her name,
Yes.
and everything else was the same. Would you be making the same argument?
I think it would not be as strong, but I think it still could be made. But
Because don't you think the totally fair inference is that the police knew her name? It's that she did not want it in the affidavit?
well, in the Rojas case, this court said that at least it was another case where someone wanted to remain anonymous out of fear. And this court said at least the magistrate should be given the name of the person for this reliability.
So you're saying that essentially this particular this person should have been treated as a confidential informant, and there either had to have been a track record or that should have been included in the affidavit. There had to be something in the affidavit.
Right, there had to be something in the affidavit beyond.
Because the police know the name of a confidential informant.
Exactly, yes, and that's other cases cited in my brief. Even if the police know who the person is, if they're not setting out the person's name, then there should be this other track record or some other information that goes to reliability.
But where this is a citizen informant, why don't all those other indicia, why isn't that a sufficient indicia of reliability? There's no indication that they were cooperating with the police, they were trying to get some benefit from it. This is a person that just came right out of the blue and said, I know I have this information. It's a citizen informant.
But even then, unless they are going to give their identification and subject to themselves to prosecution for lying, et cetera, then they are not someone who's cooperating with the police who's automatically suspect. But on the other hand, they don't get this extra reliability of someone coming forward and saying, my name is John Smith, I live at this street, and police go and check it out and they say, oh yeah, we know this is where John Smith lives, and they can follow up if this turns out not to be true. Here, she gave details that anyone could say. Like the police showed her clothes and said, are these the clothes that Mr. Cavitt wore? And she said, yes. She said that, I live at this address, but they didn't check to see if she lived at this address. I mean, they could have simply, done a little checking and put it in the affidavit, and then her reliability could have been shown. But here there was no checking whatsoever. All they know is someone called them, they picked her up in a parking lot, not her, where she lived, took her in, and she made a statement, and all it said was she wishes to remain anonymous out of fear.
So you're assuming that she did all of that with the police and withheld her name and address from the police?
Well,
Is that the inference?
it is the inference. I mean, she says, I wish.
They gave their address. They knew the address.
She gives her address, but what I'm saying is that she could have given any address, so that doesn't work to her reliability. I mean,
Isn't it just as likely that she gave her name to the police and the police chose not to put it into the affidavit?
I mean, that might be a possible inference, but we contend that it's not the substantial basis required to authorize a search. I mean, the Rojas case, in that case, there was the informant was saying that he wanted to remain anonymous out of fear, and this court said there had to be at least the name given to the magistrate.
Back to the red sneakers, the red and white sneakers, and
Yes.
and you just think that it's not reasonable to think that there would be trace evidence even on the sneakers? I mean, the person had to go from the scene where this violent confrontation happened, that is the Y, right, to this apartment in the housing complex, wearing those sneakers, or that's the inference, right?
Well, the thing is that the affidavit didn't mention the killings.
No, I know that.
Okay.
I know that.
It
But
mentioned the
it
Big
did
Y.
mention what happened at the Big Y.
Right, so all it mentions that he went into a supermarket
Doesn't it mention the robbery
for robbery, right,
and the physical confrontation?
right, but there was no, typically, trace evidence comes in a case where there's a violent crime scene.
Well, that is fairly violent, isn't it?
Well, I
You've
mean,
got-
violent, like shooting and blood and et cetera. Here,
But
I mean-
are you saying it has to be that? It has to be shooting and blood and things like that in order for there to be a reasonable probability of trace evidence?
I'm sure there's other cases, but here,
Well, breaking and entering, footsteps outside the window. They're always looking for footprints and shoes and things like
right, but there was nothing in the affidavit here saying that footprints were observed or that anyone observed sneakers or any footwear. Here, there was a robbery in flight, but it doesn't seem like it would be a violent crime scene where there might be blood splattered on the sneakers or something like that. I mean, there'd be nothing more than dirt or what would normally be on sneakers.
Or hair or something from the people that the confrontation was with?
Well, we contend that wouldn't be enough here. I mean, the cases like Shangri-Litas that I cite say that more than just contact with the person is required. Again, there has to be a substantial basis to show that the items in question were associated with the crime. And just because there was a struggle with no violence, no blood, we contend that it would not be sufficient to allow a search for trace evidence. I mean, in this affidavit, it was they described this Big Y robbery in the flight, but in concluding, it was a paragraph that had something to do with a violent crime scene. I don't know if this was a form that was used, but the conclusion, which called for the search for trace evidence in clothing and everything, which I guess justified the magistrate in finding that the search could be made, it didn't relate to the facts that came out in the affidavit. The affidavit just talked about a robbery and this struggle and a person fleeing. But the conclusion talked about a violent crime scene where all this evidence is left behind and transferred between people, and this wasn't the case here. And furthermore, it's looking to search a violent crime scene, and this wasn't the crime scene that was searched. I mean, the crime scene might have been the Big Y, but it was for a search of Mr. Cavitt's apartment.
But why would it not be enough? I mean, you've got evidence that there was a fight with the people who were following him, that he tried to grab the car door and he tumbled in the street, and the anonymous source says that he had injuries to his body consistent with being in a fight. So 3 potential reasons why there could be blood, which arguably could have been on his footwear. Why is that not
I
enough?
guess it would have been his blood, though, if it was
Be his blood,
falling.
right? But that would at least indicate that he had been in a struggle that had caused him to bleed that day. That would be probative of something, wouldn't it?
Well, I think that's going a little far in inferences from this. It has to be a substantial basis, and I don't think that provides a substantial basis. I mean, if it was a violent crime, a shooting and blood splatter all over the place, that's a substantial basis. Or if footprints were found, maybe that would be a substantial basis. But here there was nothing. There was no footprints, nothing mentioned about footwear. And it just allowed police to go in and take all his clothes, basically, without narrowing it down, one iota to, what could relate to this crime. I'd also like to mention that the Commonwealth brings up that there was also an issue of Ms. Lavoie consenting to the search. And as we discussed in the brief, we contend that that claim should now be barred, because at the hearing on this motion to suppress, the Commonwealth had its opportunity to bring up this consent and chose not to do so. If there's no further questions on that, I'd like to briefly talk about Mr. Antonio Vergara's identification. Prior to trial, Mr. Cavitt also filed a motion to suppress an identification done by 13-year-old Antonio Vergara as unduly suggestive. And here we contend that this motion should have been allowed. What happened here was this boy was brought into the police station and shown photographs on a computer screen. And I think he said he was there for about an hour and a half looking at photographs. And he picked out some photographs, none of which were Mr. Cavitt. However, at the same time, Mr. Thompson, who was driving the car, was in the same room looking on another computer screen at photographs. And he, at some point, the picture of Mr. Cavitt was on his screen. And at that point, Antonio was being let out and saw this picture of Mr. Cavitt on the screen and said, "That's the guy."
Now, do we have any reason to believe that Vergara knew that Thompson had selected that photo?
Well, I mean, I think that, again, I think that that's an inference that can be made. It was on the screen when he was walking out.
So were
But when
hundreds of
Gregaro
photos.
was walking out, yes, I'm sorry, let me just factually, when Gregaro was walking out, it was on the screen, right?
Right, yes.
Okay.
So it was on Thompson's screen. Vergara couldn't, he identified some people, but not a picture of Mr. Cavitt. He was walking out and he saw this adult, Mr. Thompson, with a picture of Mr. Cavitt on the screen. So we contend that that is akin to a one-on-one confrontation. He's looked at all these photographs, and then he sees this one photograph, especially with an adult looking at it, and says, "Oh, you know, I didn't really pick out," he says to himself, "I didn't really pick out a guy, but here's an adult, and he has this picture on the screen, and I'm going to say that's the guy."
Does the record tell us when he looked at computer images, were they always a series of different faces, or were they one individual at a time?
It doesn't tell us that. It just says that, I mean, if we look beyond the testimony to the trial testimony, all it says is he looked at thousands of photographs, but it doesn't say in what manner they were
Why couldn't
presented.
this just be one more photograph that he looked at?
Because it's one more photograph, but it's one totally separated from all the others.
Is there any indication that Thompson knew that he had not identified anybody looking through the other images?
Thompson knew that Vergara?
Yeah.
No, it
Is
doesn't. It just looks like they were sitting in the same room. They were both looking at the computer
Thompson was
screen.
sitting at his own computer?
Yes.
And there's no indication, there's nothing in the record that indicates that he saw Gregara coming by and decided to push a button with the defendant's picture?
No, if you look at the trial testimony, it says that he was interested in the picture of Cavitt, and it was expanded to fill the whole screen.
But it was purely inadvertent that he happened to see it. Gregara was...
It wasn't purely inadvertent because police placed them both in the room looking at the screens and then led him by.
But what's the evidence that Thompson did this purposely?
I don't think there has to be any evidence that
Was there any evidence that Thompson did this purposefully?
put it up and said, "Hey, look at this guy." No, there was none.
Okay.
Was there any interaction between Thompson and Gregara?
There's none on the record.
So does the record indicate that the police are leading Gregara out and he's just walking by and he walks right by?
Right. Yeah.
And so he doesn't talk to Thompson, Thompson doesn't say anything to him, he's just, Thompson doesn't even need to physically be there. There is a picture on a screen, correct?
Right. But I would say that Thompson makes this even worse because it's a 13-year-old boy,
But he doesn't know who Thompson is, does he?
but he knows that he's an adult, and he knows that people in this room are looking at pictures of people who might be involved in a crime.
Knows that? He knows that
Well,
other
I mean,
people are
knows what
looking?
he knows what he just did. So I think that it'd be reasonable for him to think that that's why people are looking at computer screens. They're not doing something else. There's pictures on computer screens.
So the guy's a victim. Maybe he thinks he's a victim.
Could be another crime.
Well, it could be, but I mean, that's why. I mean, the 13-year-old boy would think he was there. There's no reason to him think that these people aren't there for exactly the same reason.
Mr. Baylor, your time is up.
Thank you.
sir.
May it please the court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. I disagree with my brother that the Commonwealth had the opportunity to show the consent search at the time of the suppression hearing and chose not to do so and therefore must be barred. The trial prosecutor made clear at that hearing that the judge was looking at the four corners of the search warrant affidavit. He wasn't taking evidence on that point, that the Commonwealth had an alternate theory, which was consent. And the motion judge talked to defense counsel, and defense counsel said, I'm focusing on the probable cause. I'm focusing specifically on the reliability of the informant and the search warrant. And defense counsel agreed that if he prevailed on the search warrant, then he would move to suppress based on the consent if he was going to challenge the consent. So this was a situation where the Commonwealth...
Didn't prevail on the search warrant. If defense counsel didn't prevail.
Yes, I said it backwards, I'm sorry. So this was a circumstance where, like the court suggested the Commonwealth should do in Mubdi, that if the Commonwealth isn't sure about what's what in a defendant's motion to suppress, that the Commonwealth speak up. The Commonwealth says there's an alternative. The motion judge did not say, well, where are your witnesses? The motion judge expressly left it for another day with defense counsel's assent. And defense's motion for new trial wasn't that focused exclusively on the search warrant didn't have probable cause for the sneakers, but was that trial defense counsel was ineffective for not renewing the attack on the search warrant, focusing on the sneakers. So at that point, the Commonwealth was able to show, under Commonwealth versus Comita, that the defendant would have to show that a motion to suppress would be successful. There, it would have been open to the Commonwealth to show the consent search. And indeed, there's an affidavit from Detective Eugene Dean about meeting with Ms. LaVoice, getting her written consent. The Commonwealth attached her written consent to its opposition to the motion for new trial. And Detective Dean attested that the search took place of her apartment after she had given the written consent. So under a substantial likelihood of miscarriage of justice, there is no question that the seizure of the sneakers was in violation of the defendant's constitutional rights. There's an alternative basis, her valid consent. The defendant didn't attack that. They were properly seized. The sneakers were potent evidence because the DNA analysis showed that not only was the defendant's DNA profile on them with very significant statistical support, but also the female murder victims. So they were potent, but even if their seizure was error, there was other extremely potent evidence connecting the defendant. And again, there's another trail in this case from the Big Y to the dumpster where his gray sweatshirt is found, which has his DNA with a very significant statistical profile. The red shirt that Vergara and his friend Seward see the running man drop by the trees before the apartment complex has the defendant's DNA profile with extremely high statistics. In the murder victim's apartment, there's a towel with the defendant's DNA with extremely high statistics. So in light of this other overwhelming DNA evidence, the DNA evidence on the sneakers isn't the be-all and end-all. There's other overwhelming evidence. Plus, there are the defendant's admissions to Demetrius Mitchell about what he did and how he did it that jibed with the physical evidence, even jiving with the wounds to the male victim's neck.
Are you confessing error about
No,
that?
I'm absolutely not. I'm saying it is an error, but even if it was error, it would be harmless error if that's the standard that applies here. Although because the defendant really only attacked the sneakers in the motion for new trial, I submit that it's a substantial likelihood test that applies there.
If you could just respond to Mr. Baylor's argument that getting all these given what happened at the Big Y and between the Big Y and this apartment, what's the sufficiency of the basis that there's going to be trace evidence that's going to justify the sneakers being taken?
The search warrant affidavit had attached to it the police report for the complaint for the arrest warrant for the defendant. So you don't read it in a hyper-technical sense, but even though he said he didn't incorporate it, Detective Pioggia, who's the affiant of the warrant, he did attach it. In that, Ryan, one of the managers of the store who chased the defendant, positively identified the defendant through a photographic array as the person who had robbed the Big Y. So you have that evidence that's, I believe, incorporated into the search warrant affidavit. The defendant's been positively identified by Ryan, one of the eyewitnesses, as the robber.
Can I say, what's a substantial basis for thinking that the sneakers have any evidentiary value? This is for purposes of the search warrant.
The defendant fought with the people who chased him. That's in the affidavit. He also tried to get into Cavitt Thompson's car, and I think the attestation in the affidavit is that he tumbled to the ground.
So you'll see scuff marks on the sneakers or significant wear marks.
Or
Maybe.
there could be blood from like him or the two people he struggled with if they cut themselves.
Yeah, but was there any indication that they had been cut?
The informant or the anonymous citizen, who we know is the voice but not for purposes of this, she said she saw cuts on him that were consistent with him having been in a fight. So you have a fight, a fall from a vehicle, and then Cavitt having injuries consistent with a fight. The affidavit, Detective Pioggia explains that in violent crimes, there's contact with physical surroundings in a forceful or otherwise detectable manner. Here there's like forceful contact, but trace evidence can be exchanged. So based on what he attested, there's probable cause that Cavitt could have taken some trace evidence from what he came in contact with back with him, or what he had left at the scene, the clothing in the dumpster, etc. Could be.
Well, there wasn't any connection to the sneakers, was there? Did anybody say that these were the sneakers? I mean, does that just permit you to go in and get all the clothes and see what you can find? And how would you then connect?
There's nothing in the affidavit about the robber wearing particular sneakers, and there was nothing in the report that's attached to it about the robber wearing specific sneakers. So it wasn't on that basis that they were seized. I think.
Were they the only pair of footwear, men's footwear in the apartment? Or is that clear?
No, and it's clear from the testimony at trial that the defendant had two white pair of sneakers.
Right.
These are his sneakers because his DNA is on them. He also had a pair of white and black by a different brand that he was seen with. So he had more than one pair of sneakers that were mainly white.
Did the police only take the red sneakers?
I think the other sneakers may have been on him when he was arrested. I think this, I don't know if I have like the return for the warrant in here, but I think clothing and one pair of footwear were seized from LaVoice's apartment.
Did they take his sneakers at booking?
The other sneakers, there's no testimony about those having any evidentiary significance. The clothing that was put into evidence as linking the defendant to the crime were the clothing found in the dumpster, the clothing found by the tree by the apartment complex, and these sneakers.
Well, how did the police know that he was wearing the white sneakers as opposed to the red ones?
There's a videotape, a surveillance videotape of the robbery where you could, I think it's black and white, but you could tell that the person's wearing
Light-colored footwear.
Yes. But that wasn't in the affidavit for the search warrant. There was nothing about the mention of clothing that the robber was wearing had to do with what they found on the scene, which they showed to the woman in which she confirmed belonged to Mr. Cavitt. There's nothing in the search warrant affidavit about the wearer wearing sneakers, and that's why we're looking for sneakers. So the seizure of the sneakers has to go under them being an article of clothing that might contain trace evidence, which was the basis for Detective Pioja asking for permission to seize that kind of evidence. In terms of whether this is an anonymous tipster or a citizen informant, again, you don't read this in a hyper-technical sense. I think a reasonable inference from this was that she didn't want her name mentioned in the warrant, not that she didn't identify herself to the police, and it's...
Yeah, let me ask you about that. Let's assume an affiant says, I've got somebody who I'll call CI1. I know who CI1 is. Does that satisfy the veracity prong?
No, we usually want a track record of information that CI1 has given to the police officer that's been proven to be true.
So why is this different here? What distinguishes this person from the CI1 who the police say, I know exactly who that person is, I know where he or she lives, I can, if he or she is lying, I can find them and deal with them?
This is not the same as somebody who's like employed by the police as a confidential informant. This is a citizen who came forward and put her anonymity significantly at risk for her to have some kind of credibility. Her name isn't here, but her specific address is here. And it's not that the police officers investigated it and confirmed that and put that into the affidavit. It's that she exposed her anonymity significantly to the police, that she'd be entitled to greater credibility than an anonymous tipster.
Who is she afraid of?
The defendant.
Well, I mean, she said he's in my apartment. I mean, she gave all kinds of information. Anybody could have figured out it was her. Couldn't they?
I would think that he would be able to figure out it was she because he was staying in her apartment.
Yeah.
The apartment is listed.
Did the police know her name at that time?
I believe they did once she came to the police station. They didn't know who she was during the phone calls, and the phone calls were not made from her home to the police station. I think they were made from her foster mother's home. So
Is that in the record anywhere?
it's in the trial testimony. I think she testifies to how she came into contact with the police. Now, they obviously, after the fact, we know that obviously they knew who she was based on the trial evidence and on the fact that she signed a consent form, which has her name on it. But locking ourselves into the four corners of the search warrant affidavit, she gives her specific address. She says the defendant was there at the time that she's giving the information to the police. So perhaps she's hoping that based on the information she's giving, the police can take steps to get the defendant and she'll be safe.
So if you read the four corners if you confine yourself to the four corners of the affidavit, the police don't know her name, but they know where she lives. Is there anything in the search warrant affidavit that indicates that they verified that she in fact lived at that apartment?
No, and I don't know, after meeting with this female who wishes to remain anonymous, I don't know, reading it like in a non-hyper-technical sense, if the reasonable inference is that she doesn't want her name disclosed to the public, but they know they meet her face to face, they bring her to the detective bureau, she gives them information about her apartment and that she lives there with her young child. So she's not, I don't think the reasonable inference from here is that she's somebody who refused to identify herself to the police. But even if you're going to read it that way, she did give them her address. She did tell them her child lives with her there. A reasonable person would know that if that is in fact her address, they would be able to find her. And in fact, they had her. She was at the detective bureau with them at the time. It wasn't like somebody placing a phone call to the police to relay information from another site. They're face-to-face with her in the confines of the police station. She's right there. They've got her there, and they're questioning her about what information she has. So I submit that she's not an anonymous tipster, that she can be given more credibility. It's Ryan who's the one who positively identifies the defendant as the robber of the Big Y store. She identifies clothing that they seize in the dumpster and in the other area as clothing that belongs to him. She gives personal firsthand information about the defendant, telling her, after the robbery, I did something bad, and him having injuries on him consistent with a fight. So there's enough there to establish probable cause for the search of her apartment and the seizure of the clothing in the apartment based on Detective Pioggia's experience and knowledge about forensic and trace evidence, as he detailed in the search warrant affidavit. And so therefore the sneakers were properly seized under the warrant. If they were not properly seized under the warrant, they were still properly seized because with a consent to search, there's no requirement of probable cause. She's the valid tenant of the apartment. She gave her valid consent. There's been no attack on the validity of that consent, that they were appropriately seized that way, and then the police could use them in the investigation. And even if, as I said before, there was error looking at it under just the search warrant, there's other overwhelming evidence, and we're like used to the harmless error test now because of Melendez-Diaz. We've been employing it oftentimes. Here, the DNA evidence, Clarice Latham, the defendant's cousin, she says based on his mannerisms in the security video from the Big Y, she's positive that he's the robber. To the defendant's admissions to Demetrius Mitchell, which are quite detailed, to the towel that's found in the victim's apartment that has his DNA, the gold chain, which has inconclusive DNA, but it's not covered with soot, and the floor beneath it is clean of soot. And the voice had said that the defendant had been wearing the chain, and she positively identified it as hers. And going to the chain, I'd like to address the inconclusive DNA testimony about the test on the chain. This is slightly different from Matei. I know that statistical support is supposed to go in with inconclusive test results, and the court recently reaffirmed this last month. Here, it was not non-exclusion test results, which in Matei kind of differentiated from the Mitchell case. This was, the chemist said, I can neither include the defendant nor exclude him. As I said before, there's an abundance of DNA evidence linking the defendant all the way through, from the robbery all the way through to the murders, apart from the necklace. So unlike Matei, this inconclusive evidence isn't the thing that's linking the defendant to the crime. And in light of all the other, and the prosecutor here didn't use it that way. He said the lab can't tell us anything about it, but the voice identified the thing as her necklace. That's what he stressed. So if it was error to put in can't exclude, can't include without any kind of statistical backing, it's harmless in light of the other overwhelming DNA evidence and the fact that the prosecution didn't misuse it, and that it came in more like the Mitchell case than the Matei case, where in Matei it was that the defendant could be included but not excluded. It wasn't worded in a prejudicial way here. It was this and this. So in light of that, there's no reason to reverse. Under 33E, the jury came back on all three theories of first-degree murder. The Commonwealth's theory on felony murder was that the murders were in the commission of the robbery, in that they were in the escape from the robbery. And recently, this month, I think it's the Bacon case, but it's like April 8th of this month, it was a different situation. It was the defendant struggling with the security guards as he was leaving the store, where the court talked about whether escape from the felony can be sufficient for felony murder is a question for the jury, and it has to be some temporal connection. The temporal connection here is the robbery occurred about 8 o'clock. The two little boys, Seward and Vergara, see the struggle at about 8:02 based on their CVS candy purchase receipt. and Lieutenant Freiberg of the fire department sees smoke coming from the victim's apartment a few minutes after 8. So temporally, it's extremely close. It's within a few minutes of the robbery. If the court finds that that wasn't sufficient for felony murder, there's still deliberate premeditation and extreme atrocity or cruelty, which are substantially shown by the evidence. I'd submit that there's no basis to reduce the verdict or to grant the defendant a new trial.
Thank
Thank
you,
you.
counsel.
Yeah, can we take a short?
All right, we'll take a short break.